Good morning, and welcome to the SJSU Plan Giving virtual seminar series. My name is Nick Messing, and I'm the Alumni Engagement Specialist at San Jose State. The seminar series continues today with our webinar, Top 10 Myths and Common Mistakes in Planning Your Estate, brought to you by the Office of Plan Giving in partnership with the SJSU Alumni Association and Special Events. We want to thank our presenter, Lisa Bryant, CEO of the Law Offices of Lisa C. Bryant, Inc., for sharing her time and knowledge with us today. We will start off with some brief housekeeping items, followed by the presentation, and we'll conclude with a Q&A session. At the end and throughout Lisa's presentation, you will have a chance to ask questions. Please submit questions using the Q&A button on your toolbar anytime during the presentation. There may not be time to answer every question during the Q&A, but we will download the chat and follow up with any unanswered questions in the next few days. Please keep comments appropriate or we will remove you from the webinar. Please be aware that we are recording today's event and it will be available to view on our website in the near future. Lisa Bryant graduated from San Jose State with a bachelor's degree in political science. Following her undergraduate degree, she worked for several nonprofit organizations, which reinforced Lisa's desire to be of service to her community. After graduating from Lincoln Law School, Lisa created her own law practice from the ground up. Lisa focuses her practice on estate planning and elder law. She passionately advocates for veterans, seniors, and hardworking families. She regularly counsels clients on more complex estate planning issues, including Medi-Cal planning and special needs planning. Lisa prides herself on taking a personal and practical approach to each client's situation. She's had her own practice now for over 13 years. Lisa is a member of the National Academy of Elder Law Attorneys and the California Advocates for Nursing Home Reform. She's also a certified mediator. This and other seminar supports SJSU's mission as a center of knowledge, including estate planning and financial literacy. Without further ado, please welcome Lisa.
Thank you so much for having me. Good morning, everyone. I appreciate your attendance. I'm looking forward to our seminars this morning. I'm going to go ahead and share my screen. Okay, so true or false? If I have only a will, my family is protected from the probate process. This is a very misconception. This answer is false. What a will does is it actually sends it to the probate court. The probate court right now in Santa Clara County is taking about 18 months to go through the probate process, and that's with no one fighting. That's with everyone on board and just trying to get it through. What the probate process does is it appoints a person to be in charge, and then the court determines how your assets go according to a table that it has. So in order to avoid the probate process, you're going to need to do a living trust. So again, as you see on this slide, if you own real estate worth more than $55,000 or personal property worth more than $166,000, you have to have a living trust. A living trust, you want to think of it as a box, and you are in charge of this box. You are known as the settlor, the grantor, the trustor, all the same person. And you put all of your belongings into your box, into your living trust. During your lifetime, you are the trustee, the person who manages and controls your belongings. But should something happen to you while living or when you're deceased, we name a successor trustee, someone who comes in and takes over for you. And this allows it to avoid the probate process and just be administered outright to your beneficiaries. Myth number 2, if I have a living trust, I do not need any other estate planning documents. This is very common in what I do because many people may not own real estate or they have their children on their bank accounts, other ways in which they try to avoid probate, but realize that there's much more to a living trust than avoiding probate. You're going to need other documents. Everyone should have a power of attorney and a healthcare directive. These documents are separate from your living trust. They are physically separate documents. A lot of people believe that they are contained within the trust. They are not. A power of attorney comes in 2 forms. One is a springing power of attorney, and the other one is an immediate power of attorney. A springing power of attorney springs into effect when 2 doctors sign off on your incapacity. I want you to take a moment and really think about, do you have 2 doctors in your life? And do you have 2 of them that would be willing to say whether you have capacity or not? A springing power of attorney can slow down your children from being able to take care of your day-to-day finances, to pay your PG&E bill, to deal with your checking account, to go ahead and deal with Medicare and your insurance. So you may want to consider an immediate power of attorney. An immediate power of attorney allows the agent to take action right away. No doctor notes are required. Of course, this comes to a point of trust, because if you do an immediate power of attorney, you are giving your agent authority immediately. However, they don't have to act on it until needed. So although they have the authority today, as long as you do not share that power of attorney with your bank or any other financial institution, that person does not have any access or control. So it's something to think about and to have reviewed. Take a look at your power of attorney and see which type do you have. The second myth is most people believe that a power of attorney is good like a trust, like it goes beyond your lifetime. A power of attorney dies when you die. It is only good while you are living. So a power of attorney controls the assets that are not in the trust, and the trust and the trustee control the assets that we put in the trust. So two different documents, two different things. You must have both. The next one is the Advanced Healthcare Directive, also known as a living will. Kaiser calls it 5 wishes, all the same document. But here you want to make sure that you have marked your wishes on life support. Do you want to be an organ donor? Do you want to be cremated or buried? This is very important. This document is what releases your body to your agent for burial. If you happen to not have a healthcare directive, it's going to take the majority of your living children or heirs to release your body. So you want to make sure that you have a healthcare directive, because if your children are not local or cannot be reached, it can become a very, very cumbersome and difficult process for your family. So a healthcare directive and a power of attorney is a document that anyone needs, no matter what your wealth or status is. This one is a very big one that I see in my practice. So I like people to give it a lot of thought. It's what I call the denial of the family dynamic. My children are so very different, but to be fair, I need to put them all equally in charge of my affairs. I want to tell you, maybe not. Think this through and be sure. Treating your children equally is not often a good idea when it comes to putting them in charge. They can be equal beneficiaries. They can receive equal benefit of the trust, but someone has to be in charge of the actions of the trust itself. So how we choose a trustee is very, very important. When you pick co-trustees, when you put all your children together, they do have an equal say. And therefore, if their personalities are very different, that's going to be very, very difficult. They have to work together. Many times they have to be together physically in the same place. So that's also difficult if they're in different locations. But more importantly, you really want to think about who has the time to do this. It's time and aptitude, truly. When we do a trust administration, when you pass away, the law and the terms of the trust really administer the actions we're going to take. The trustee simply needs to just be able to exercise good judgment. No one who has a lot of risk taking, someone who's willing to follow legal advice and take direction. And then like I said, someone who is not undue influenced by their family. More of a neutral is the personality that you want in this. A lot of people default to the oldest child. A lot of people will default to all 3 of them together. You really, really want to give this some thought, because this is where it gets hung up. The number one fight that people have with a trustee is just getting started, is the fact that mom or dad passed away a year or 2 ago and they simply have taken no action. Anytime that you prolong a trust administration, you're looking at more tax filings, more capital gains, just a few more issues. So you can wait some time, you don't want to wait years. So you do want to have the person in charge who is willing to, after 3 to 6 months, start the process and work it through. So we just want someone who has the ability, the time, and the aptitude to go ahead and do that. So I'm going to go ahead and pause there for a moment and ask, are there any questions about the first 3 things we talked about today?
Yeah, so we have a few questions in the chat. Again, continue to submit your questions either through the Q&A function or through the chat. The first one, this is going back to myth 1, is how long does it take to settle a trust?
On average, a living trust can be settled in somewhere to 5 to 7 months. By law, there is a 120-day wait period from the time you start trust administration. That is not from the time the person has passed away. That's why it's very important that your agent start right away, not wait too long, because it's 120 days from the time we start. And then, depending on if we're selling a house or what we're settling, it could take a little longer. And then we have to file the final tax return, and then the trust will be distributed. On average, 4 to 6 months is the average, as opposed to probate court is right now running at 18 months.
All right. The next question, what's the transfer on death account?
A transfer on death account is simply that. Typically, it's a bank account. It can be a brokerage account, but it's just that. It's upon death, it transfers to the beneficiary that you name. The downside of that is that a lot of people will name their one child when they have 3 with the intent that the first child will share it. The reality is they may or may not. By law, they do not have to. It is 100% theirs. They don't need to share. And then if they want to share, there could be tax filings involved in what we call a sibling to sibling transfer. An inheritance is tax-free up to $11 million. But when you transfer between siblings, it's a gift. And gifts have different requirements. So a transfer on death account could work for some people. We just want to review it and make sure it's the right way for you. And then if so, just knowing that whoever you're transferring it to, that's where it's going to be. The downside of a transfer on death account is that it is only good at death. What if your children need to get into that account while you're living? We need to pay for your assisted living. We need to pay a medical bill, whatever it may be. Unfortunately, they do not have access to that account until you die on a transfer on death account, unless they have a power of attorney. So we need to make sure you minimum have that document. Next question.
All right. Next question. If you don't have children and plan to leave all of your wealth to charitable organizations, which are beneficiaries on brokerage and credit union account, why have a trust?
If you own a home, you need a living trust, most likely to leave it to them. It depends again on what you own. But I'm further down, we're going to get into a slide called a living trust, how it serves the living, because it's more than just passing assets at death. But it's more important, if you have real estate, you need a living trust in that situation. Otherwise, likely it could pass to the charities through the beneficiary forms on those accounts.
Okay, the next question was, can you please explain again the distinctions in power of attorney?
Sure. Again, powers of attorney, commonly you refer to it as a durable power of attorney. It's another term you're going to see. Power of attorney come in 2 forms. A springing power of attorney, meaning that it springs into effect upon your incapacity. And this will be stated on the front page. And it will say that it requires 2 doctor's notes to determine that you're incapacitated before your agent can take action. That's the first type. The second type is an immediate power of attorney, meaning that it takes effect today. And again, on the front page, it'll say that this one takes effect not in conjunction with your incapacity. It just takes effect immediately. And those are the 2, requiring doctor's notes, not requiring doctor's notes. So we just have to determine which is the best for your situation. The older you get and the more stable your children are, the more likely you want an immediate power of attorney, because getting your parent or loved one to one doctor is hard enough. Getting them to 2 doctors can be very, very difficult. And so an immediate power of attorney allows us to take action right away.
All right, I think those are the questions for right now.
Okay, so we're going to go on. This is another big problem I see with many, many people. I'm funding my living trust. My living trust is funded by the Schedule A at the back of the document. For those of you who have a living trust, you most likely have a Schedule A. Prior to 2015, we may have even typed out all of your accounts onto the Schedule A, Wells Fargo, Bank of America, etc. And then come to find out you changed banks, and now it's no longer up to date. So people really don't understand how to fund their living trust. To fund your living trust, you must physically go to your bank or talk to your financial planner and change the names from your individual or joint names to the name of your trust. It must appear there as trustees after your name. It should appear on both the statement and, if you have a checkbook, on the checkbook. If you do not physically change it at the bank, it is not in your living trust. The Schedule A is simply a suggestion. It tells us where to look, but it does not carry legal weight to really have it in the name of your trust. You must fill out the paperwork at the bank. So when you do a living trust, you do a document that's called a certificate of trust. Typically, it's 2 or 3 pages long, and it's a summary of your trust. What it says is who is in charge, who are the trustees. This is the document the banks want to see. So if you have an older trust and you're not sure if you have a certificate of trust, you need to take a look, because this is the legal document that allows the banks to add your names to the account. So that's what they're going to want to see. Here in the middle of my slide, you'll see that IRAs, 401ks, and 403b accounts do not transfer to your living trust. An IRA is an individual retirement account. Therefore, it's easier and better tax-wise to transfer it to an individual. So you want to leave it on a beneficiary form. So you want to transfer it from person to person. If I transfer your IRA from a person to your living trust, which is a thing, it's going to be taxed at a much higher tax bracket, and it's going to have to pay all taxes immediately. So remember, IRAs, individuals, transferred individuals, and everything else can go in your living trust. Lastly, you really want to make sure that you have recorded a property deed to transfer to your living trust. That is not automatic. Many attorneys sometimes will prepare the deed and give it to you to record, but you are not aware that you needed to record it. So a lot of people their property is not in their living trust the way they think it is. So that's something you definitely want to check. There's 2 steps to property. One is your deed, which must be recorded with the county recorder. And the second is the county assessor, your taxes. Sometimes your trust name can appear on your property tax bill, but it's not recorded with the recorder. They don't always talk to each other. How this happens is that you did your deed, you transfer it to your living trust, and you informed the county assessor, so they have you on file. But then you refinanced. And when you refinance, they take your deed out of your living trust, they do their paperwork, and they're supposed to put it back into your living trust. Half of the time, the refinance companies fail to put your property back into your living trust. So you thought it was there all along and kind of find out it's not. So it is really important to just pull your property deed from the county recorder and make sure that it is up to date, especially if you have refinanced. You really want to check and make sure it's there. And then myth number 5, an estate plan is all about property and belongings. Why do I care? I'll be dead. I get this a lot. A lot of people just aren't sure how does it serve them. This kind of goes to the charity concept of handing it out, the previous question. But the truth is, estate planning serves the living. It's a living trust. Death is easy in the sense that it is final, and therefore the acts that you have to take are certain. What becomes uncertain is we become medically incapacitated. If you have a stroke, 50% of people are going to have dementia. So if you get dementia, if there's any way in which you cannot care for yourself, we need to have someone step in and care for you. And that's going to be your successor trustee. This allows them to get a reverse mortgage on the house, to take out a loan if they have to sell it if they need to, whatever they need to do to make sure that you are cared for. So a living trust serves the living. By not doing that, you could end up in the court in what we call a conservatorship. And a conservatorship is where we appoint someone to step into your shoes, but unfortunately it's time consuming and expensive. And then the trustee or the conservator at that point has to report back to the court regularly, and that's just ongoing financial issues. So we just want to make sure that you have all your documents in place to avoid a conservatorship. An estate plan allows you to name a guardian for your children. That's very, very important. when you pass away, emotions and death affect people differently. Some people feel like they may have wronged you in life, therefore they want to make it up to your kids. And they think that they're going to be the best guardian for your children. Not true. So the reality is you want to pick that person. You want to put that in place. Otherwise, it can become an argument between your family and your in-laws on who may be best for your children. So it's very important for people who have minor children that we have to name a guardian. If you have any disabled children or now disabled adults, it allows us to put money into special needs trusts and other things that allow them to receive government benefits. The government benefit is not the $800 SSI check. That's not the important part. It's the programs they're in. If they are in adult housing, if they are receiving any kind of physical therapy or emotional therapy, caregivers, education, these things, these programs do have limits on what they can receive and what they can inherit. So we want to make sure that we put everything into the correct trust for them so that these programs are not disrupted. And of course, as we spoke of earlier, an estate plan minimizes the ugly battles because it's in writing. It has parameters. It has an attorney to guide the family. It helps us kind of eliminate that. But it's very important that you have some legal documents in place, because what happens if you don't just die? No one in a nursing home said, this is my retirement plan. You just don't know. But it's very important to make sure that we have everything set up should we need to, because only you can set those documents up before an event. And that's where it becomes very important. So I'm going to stop right here and see if we have any questions about the last few things we spoke of.
Yes, the first one. Lisa, can you expand more on how to handle a trust for those without children?
Sure. If you don't have children, and the first thing to consider is who would be the trustee, who will be in charge. Now, there's 2 points to this. One is who's going to handle the money and who's going to handle the health. We may want to consider a family friend, a brother, a niece, or a nephew to deal with your medical decisions. It's a much more personal decision. They may know you better. They'll know what you want. They'll be able to react. The second side of it, when it comes to money, we can hire what's called a private fiduciary. This is someone who is licensed and bonded by the state of California and is a trustee professionally as a job. Therefore, we can hire them to step in and manage all things financial. This can be while you're living or deceased. When you're living, a private fiduciary will help pay your assisted living bills, your mortgage. They'll step into your shoes for you with the banks and with your financial planners. And then upon your death, they will administer the trust according to your wishes, to your charities, to your distant relatives, whoever it may be. It is very important for single people to also have a power of attorney and a healthcare directive, because no one can access your accounts automatically. For married couples, if the accounts are joint, then you can get to them. But if you don't have a joint owner on the account, these documents become more and more important.
All right, next question. Do you need an attorney to prepare a power of attorney?
Okay, well, that's another slide I'm going to get to regarding what we call the do-it-yourselfers. Yes, let me tell you, because there are power of attorneys, financial power of attorney online. It'll say statutory durable power of attorney. And what it does is it lists out like 10 things your agent can do. And at the bottom, you just initial and it says everything above. And it has little lines in front of everything. So it looks like a list, and at the bottom, you sign it. That one is no longer being recognized at many, many financial institutions. It's very generic, and they don't like it because it just doesn't give enough detail on what you can and cannot do. A financial power of attorney should be 10 to 20 pages long nowadays. The one I just spoke of typically is 2 to 3. It really needs to spell out. And the more we are doing digital passwords and the more things that are online, the more detail your power of attorney has to have in order to get access to that. And a power of attorney, if you want to be able to get to IRAs and other accounts, you need a much more detailed power of attorney, because the statutory one is not going to meet it. So as an attorney, I would never tell you to go online and do it yourself. Can you? Yes, but you will run into problems with it. You just really want to see an attorney. A power of attorney is not overly expensive. So it's worth paying for. An advanced healthcare directive, the living will, Kaiser's 5 wishes. That document is widely available on the internet, and that one is pretty good across the board. Those documents really do stay standard across the board. You just want to make sure, does it speak about whether you want to be on life support? Does it speak to organ donation? And does it talk about your burial, who you're appointing to take possession of your body? If it covers those 3 things, then that document is fine to get off the internet.
Great. Can you expand more on how to find a reputable private fiduciary?
Sure. In California, it's called the PFAC, the California Association of Private Fiduciaries. There is a website that lists them for you. But also, you really just want to talk to other attorneys or talk to an attorney, because we have ones that we use regularly that we know are just more grounded and more established in the industry. And then, of course, we want to figure out, what do you want your agent to do? Sometimes we really do want someone to help mom with her healthcare decisions, take her to the doctor. If we're looking for a more personal touch, then it's an individual private fiduciary. If we have a beneficiary, let's say, that has a drug addiction, has a personality disorder that nobody's going to want to deal with, but unfortunately he needs somebody to deal with him, then we might consider using a bank. A bank is a little more cut and dry. They're not going to put up with a lot. They're going to put this gentleman on a budget, and they're going to give him a certain amount, and that's going to be that. So it really depends on what you're looking for. So any estate planning attorney can refer a private fiduciary, or again, the California Association of Private Fiduciaries. PFAC is the name of it. Will also be a good resource on the internet.
Right. Can I list my living trust as beneficiary of my U.S. federal thrift savings account?
If it is a tax deferred account, it is better to put it to a person. If it is simply a brokerage account, then yes, you can list your living trust as the beneficiary. However, again, if it's your beneficiary, it can only comes to the living trust at death. I want you to put the name of the living trust on the account today. So because if you become incapacitated, your agent can step in and help you. If it's listed as a beneficiary, they cannot. So again, better to title your assets in the name of your living trust today. And that is actually changing the title, not leaving them as a beneficiary form, because the beneficiary form is only good at death. And what happens if you don't just die?
Okay, we'll do one more, and then for this section, in a common property state, do we also need to have a joint account?
So is that, I'm assuming that's meaning in a community property estate. I mean, I'm assuming the question's about community property or not.
Yes, they said. Yeah.
Okay. No, you're never required to have a joint account. This is very common in people who are having second marriages or marriages later in life, that they keep their assets more and more separate. You can even have your own separate living trust. We can put your half of the house in your living trust according to your wishes, and his half in his trust according to his wishes. So although we are a community property state, it doesn't really, there's different ways of planning that we can work around to do it. No, if you have an individual account, though, you are married and you have an individual account, just because you're married doesn't mean that person, your husband, can get to that account. So again, you would need a power of attorney, or that account needs to be in the name of your living trust in order for them to receive it. So an account in an individual's name, even if that individual is married, is still treated individually, and the spouse cannot get to it immediately. So just something to think about, to make sure you have a power of attorney in case your spouse needs to get to your individual account.
I think you covered that a little, but someone asked, can spouses have separate trusts, especially if they really wanted to segregate their assets?
And the answer again, absolutely. And you can even do what's called a post-nuptial agreement. Most people have heard of a prenup, where we get into agreement before we get married. You can actually make an agreement after you're married and decide what you want. And you can put that into writing as well. For example, I inherited a house from my mother. My inheritance is my sole and separate property. I keep that in my own trust. However, my husband is helping me put on a new roof on my house. Now, does he have any interest in my separate property now that he's put his money into it? Maybe. There's questions about this. But if we come to an agreement between you, it doesn't matter. So there's always ways to work this through. But yes, you can always keep things separate, and we can keep them as completely separate as we all agree to do if we do a post-nuptial agreement.
Great, that's all the questions for now.
Okay, I'm going to move on. This kind of went to the one that we went to. I don't need an estate plan. My daughter's on my bank account and the title of my house. What's the problem of putting your kids on your accounts today? This is a one that I have seen go badly so many times. Please think about it before adding your children to your assets. By adding your kids to your house, it is now their house. They get divorced. Your house is part of their divorce settlement. His ex-wife now owns your house. And this is very true, and this happens. So there is no reason to add your kids to your assets today. You'd really have to give me a convincing reason, because I said they get sued. It's up for their lawsuits. Accidents happen. They get in a car accident. You never know. And suddenly the things that you believe were there for you are now reached by their creditors. And that becomes a big problem. Excuse me. By doing this too, by putting your kids on different accounts or assets, it can trigger tax implications. When you die, you get what we call a step up in basis, meaning that whatever you bought your house for will step up to fair market value when you pass away, and the kids inherit it at that fair market value. If they sell it, no capital gains tax. If you put a child's name on your property while you're living, they don't get that step up in basis. So you bought your house for $50,000. It's now worth $1 million. They go to sell that house, they're going to pay capital gains tax on the difference, simply because you added their name to the house too soon. You really, really need to be sure about when to add children to your account or your home. And lastly, if you have multiple children, again, it goes to the child whose name's on it. You think they're going to share. They may or may not. Death and money bring out the weird in people, and you really, really want to consider that. And more importantly, who is influencing your children? You might know your kids, you don't know your in-laws. And so we just don't want to create these things where we're putting all the pressure on one child to share with the other siblings. Because then again, there's tax implications when it passes from sibling to sibling as opposed to an inheritance. If for any reason you have added your children to your property and are reconsidering, if your children are willing to give it back to you, you can do that without any change in your property tax. There's no reassessment. A transfer between parent to children or children to parents is fine. So we may want to consider undoing that and putting it in your living trust and let them inherit it so that they get the full tax benefit when you pass away. Myth number 7, taxes will decimate my estate. A lot of people believe that it's just all going to be eaten away anyway. Therefore, if I do an estate plan or a living trust, the government's going to know, and they're just going to come after me. But I can just pass it. My kids know what to do. They know it's theirs. They'll take it. No. Legally, it just never happens that way. Anywhere in the United States, if you're passing real estate, real property, you need to have legal documents to go with it. Nothing is automatic. No matter what your kids know about your wishes, it's just not going to happen. So under the current law, right now, the tax exemption is $11.5 million. Very few people meet this. And for a married couple, we're up to 22 million. So very few people are going to have tax implications about their estate. So this is where you want to hear anytime that the death tax or the estate tax is being argued in Congress, the reality is it affects very, very few people, and it doesn't really affect the majority of Americans. The problem, I'll go with the problem with the estate tax being so high at 11.5 million, is that many people have what's called an AB trust. If you did your trust before 2015, it is likely that you have an AB trust, meaning upon the death of the first one of you, the trust splits in two. And this is done along community property lines. So half to the living spouse, half to the deceased spouse. The problem with this is that the living spouse cannot touch the deceased spouse's side. They are stuck with some restrictions on it. Typically, it's 5% a year, and they have to have permission from the beneficiaries. And then it has to file a tax return every year from this person's death to the time the second person dies. It just creates more havoc and more cost, and people just are not aware of how limiting it is. Because a lot of people think if I need to sell my house to pay for assisted living, I can do so. No, you can't, because half of it is stuck on your deceased spouse's side, and that side is irrevocable, meaning it can't be changed. So this can cause a lot of court action that we have to go to try to change it. So I highly recommend, if you did a living trust before 2015, you need to have your trust reviewed and see if it is an A-B split. And if so, we can simply change it to a more easier, user-friendly version of a trust. But you definitely want to make sure, because A-B splits sometimes are mandatory within the document. So we want to make sure. I'm going to stop here and see if we have any questions.
I think we haven't had many come in right now. So for sake of time and questions at the end, maybe we want to just move on, and then we'll collect a few more questions as we go, and then have plenty of time for Q&A at the end, if that sounds good.
Sure. So our next myth is, I don't need an attorney. I can draft my own estate plan. You don't know the law, and so you don't know what you don't know. So please don't draft your own estate plan. Because a lot of the common errors that people get when they do their estate plan, the number one is you're missing required legal documents. A lot of the times people will draft what they believe to be a trust, but they fail to do the deed to their house. And of course, if you don't do the deed to your house correctly, you can also have tax implications should you've not told the county assessor correctly, we don't want you to be reassessed, and et cetera. So you can always have missing documents. A lot of times people are missing the power of attorney in the healthcare directive. You can have wrong words or omitted words, and it just doesn't read the way you think it reads, but legally, there is a difference between our trustee may do this or our trustee must do this. We really got to figure out what your wishes are. Blended families, this becomes a very big one. Please don't do it yourself, because we want to make sure that what you brought into the marriage goes to who you want, and what they brought in goes to who they want. And when you try to do it yourself, you get very convoluted when it comes to who's in charge of which portion of the trust and what we're titling these things. Instructions about your property is vague or confusing. I get a lot of people who say, I'm going to leave my ring to my daughter. Well, mom owns 10 rings. Which ring did she mean? This can become a battle that people are just, the hill someone's going to die on kind of thing. And we want to make sure that it's very clear in what you want and who gets what. Lastly, to LegalZoom, and for those who've done it on LegalZoom has settled a class action lawsuit, just because what LegalZoom can do for you is a very generic template. But what a lot of people don't recognize is when you do a living trust, you have to do a will, a power of attorney, a healthcare directive, et cetera, et cetera. And LegalZoom, these are add-ons. And if you didn't know you needed the add-on and you didn't add it on, then you're stuck similar to this case, where she didn't have the documents that she thought she had, didn't get what she thought she paid for. And come to find out, it really, really did cost her a lot of issues. So if you have a living trust by anyone, like LegalZoom or what we call trust mills, typically insurance companies will do them as well, please just make sure to have it reviewed by a lawyer to see if it is up to date. Our last one is trusts are overly complicated and expensive. The average cost of an estate plan, which will include the living trust, the pour-over will, the healthcare directive, the power of attorney, a HIPAA form, the deed to your house, the county assessor forms, a certificate of trust, a community property agreement if you're married, and about 5 other miscellaneous documents, on average is about $3,500 to $5,000. As you can see from this table, probate fees are set by law, non-negotiable. It truly is a win for an attorney to get a probate, because we're not going to argue over fees. As you can see from this table, it can get up there very, very quickly. Probate goes by fair market value. They do not care about your mortgages or your debts. So although you may have $1 million house and you owe 800,000 on it, your probate fees are going to be on $1 million. So here in Santa Clara County, take a look at this table, and where do you think you're falling in? If you own a house and have 1 or 2 accounts, you're up there very quickly in probate fees. So you just want to make sure that you have a living trust. Besides the time and the headache, it really is much more cost effective to do a living trust. Lastly, these are other myths that people think about when they talk about estate planning that I hear that people just don't know. So right now, I'm just going to open it up to the rest of the questions and any other things that may come up.
All right. Can you expand on how to avoid the house transfer to children?
When you own real estate, you need to put it into a living trust. By creating a living trust, the deed is in the living trust. You're the owner. It's under your control. Upon your death, it'll say who it goes to, and then it will transfer the children upon death. There's no getting around it in California. If you own real estate, you've got to have a living trust. Or yes, you can put your kids' names on it, but be careful because they said they're losing tax benefits by doing that. So the only real way is a living trust.
All right. What's the typical cost of a trust, power of attorney, and healthcare directive?
For an estate plan, an estate plan is just a combination of all those documents together. An estate plan on average will be about $3,500 to $5,000, depending on how many properties you own or what you own. At my office, a flat fee estate plan with 1 property is $3,800. And that includes all the documents we spoke of and a few more.
All right, thank you. If you're on a limited budget and pretty savvy, what about using something like Susie Orman's Trust Wheel software, then going to a lawyer like you to review and alter final documents?
I'll tell you that, for example, I don't know that I would review a Susie Orman trust, to be honest. Simply because she is not a lawyer, I cannot speak to what she is doing. And Susie Orman is not an attorney. Please look her up. Therefore, the legal documents that she is supplying you is not necessarily a legal document. So we'd rather just start over because that way I can be sure on what you have. At least LegalZoom is run by attorneys and done so. Susie Orman is not. She's a financial planner background. So just be sure about it. Most likely we would have you'd end up redoing it on some level because I'm sure it's missing portions within it.
Okay, thank you. What's the cost estimate for reviewing a living trust prepared before 2015?
A living trust review is, at my office, a living trust review is free. We'll look at it together. I'll tell you the good and the bad about it. If I think there's any changes that need to be made, I will tell you there. I'm a flat fee attorney. I don't charge by the hour. So I'll quote you a price at the end of our meeting. We'll have agreement to make the changes or not, and that'll be that. But the review and the meeting is free.
Right. Another question that was from earlier. It says, on post-nuptial agreements, would the spouse inherit the other spouse's liabilities, which I believe you covered?
We're a community property state. On some level, yes. There's no getting around community debt. If it was created during the course of marriage, there's really no getting around it. However, we may be able to set aside different assets that belong to one spouse to cover that. For example, this is very common in what I do is that husband and wife have separate accounts. So but he's declining much faster and he needs assisted living or memory care. We will have a post-nuptial that lets his family know that we're going to spend down all of his IRA and his assets first before we ever touch community assets. That's very common in a post-nuptial.
Okay, did the recent Prop 19 affect any of this property transfer to children?
Yes and no. Prop 19 is most likely to be overturned, to be honest. It's a poorly written law and it's already in the courts. But what it does is that it makes the house that you're leaving your children needs to be their primary residence in order to qualify for some exemptions right now. But the chance to avoid Prop 19, that period's already went and gone. That was early March. So right now we are stuck with the law how it is, but not likely to remain, to be honest. It'll probably be overturned here fairly soon.
All right, I think we have time for one or two more questions. The next one is there any way of signing a post-nuptial agreement revoking each other's community property rights in your own specific assets, except for their house?
Probably, but when we write these things, you have to stick to the letter of you have to stick to it. So my point being, we say that you pay for this from that and this from this account. If you ever cross mingle, if you ever step outside of your agreement and do it, then you've invalidated the agreement. So we'd have to see. That's a much more detailed question that I can't answer without knowing what we're talking exactly about and what we're trying to restrict. But again, community debt cannot just be erased by writing it out. We have to see what we're talking about for a more clear answer on that. I'm sorry.
All right. Are there any alternatives to putting real estate, if your only property is your house, into a trust? And if not, how much would that cost?
Again,
trust fees being reasonable.
in your mind, your only property is your house. In Santa Clara County, that's $800,000 to $1 million right there. But you also have a checking account. Your pension or Social Security check goes somewhere. You also have the things in your house. You own a car. So you have much more in your life than you're aware of right there. But yes, you can do a transfer on death deed if you have one child you want to leave it to when you die. But again, it's not about dying. If you become incapacitated and we need someone to step into your shoes to care for that house, sell that house, refinance that house, do anything, that can only be done through a living trust. So, or a power of attorney, depending on if we did the transfer on death deed. So it's much more complicated than that. But again, a living trust, $3,800 for everything, and it's done. So it'll go up and down from there depending on what we need to do. But with real estate, it really is a living trust in order for your children to get the best tax implication. We want to make sure they get the step up in basis, because here in the Valley, think about what you bought your house for. A lot of my seniors paid $30,000 or less than $100,000 for their house, and it's worth $1 million or more now. That's serious capital gains tax if you don't set it up correctly.
Right. Should you specifically name assets like vehicles, artwork, jewelry, etc., to go to specific people or kids in your trust?
Yes, please. We appreciate it. It really keeps the fighting down. It's the stuff that people are going to fight over. It's the sibling rivalry comes out in very strange ways, and typically it is the stuff that people are going to fight over most. The number one thing people fight over is mom's wedding ring. That's the first one. So who gets the jewelry? Who gets mom's wedding ring? Then it is the things of value: art, musical instruments, expensive cars, tools. These kind of things are very important to list them out. And the more detailed you can be, the better. It's the less fight that we have to have, and the more that we can just move this along faster.
All right, I think we're going to do about two more questions that we have. The first one is, do you advise on issues of mental, physical incapacity of one spouse in a living trust?
Yes. Besides estate planning, a good estate plan or a good living trust allows us to plan for long-term care. What happens if we do become incapacitated? So our first one is we need to see how to remove the incapacitated spouse from being in charge. And then second, do we have the paperwork necessary should we need to require benefits down the road to help pay for in-home care or skilled nursing care if we need to go on Medi-Cal or any other benefit also. So yes, incapacity planning is a big part of estate planning, and it's a big part of mine. My clients on average tend to be 55 and over, or the adult children of my seniors.
All right, our final question for today is someone would like more info on the post-nuptial agreements, like plus or minuses, and the cost of that.
Okay. I do not do post-nuptial agreements because it is somewhat of a conflict with your estate plan. So you do it first and then we create the estate plan. But I do have a person I recommend for it, and they do offer a free consultation for that. So if you just reach out to me, I'd be happy to pass that along. It's a family law attorney is the person who drafts a post-nuptial agreement.
All right. Well, I think that is all the time we have for now for questions. And thank you again, Lisa, for joining us.
Thank you for having me. I enjoy doing it. Thank you for all your patience with my technology.
And thank you to everyone else who was able to join us today for our virtual seminar. Our featured speakers in this Plan Giving seminar series are experts in a variety of fields, including estate planning, trust law, wealth advising, real estate, tax, and charitable giving, and they've graciously agreed to share their time and knowledge with the SJSU community. Our next virtual seminar will take place in June, and we look forward to seeing you then. If you have any additional questions or wish to get in touch with the presenter, please contact Randy Baylog, SJSU's Director of Plan Giving, or visit us on the web at legacy.sjsu.edu. Thanks again, everyone, and have a great day.